the state has very significant concerns about the flight risk that this defendant poses. The allegations here is that he was engaged in basically a fraudulent investment scheme that defrauded a number of his friends and acquaintances in Dover to the tune of around $300,000. There is not a lot that would incentivize him to stay here. In fact, we're very concerned that given the opportunity, he would leave. His home that he owns is in the foreclosure process. We're not quite sure when that's going to happen. We're not sure where he would live once that happens, who he would live with, and who would live in proximity to him, and how he would support himself. You know his mother and sister have left the area and they moved to North Carolina. There's no indication that he has employment. There's no indication that he has any means of support. In fact, the past 2 years he seemed to have no legitimate means of support other than defrauding investors and using their money to support himself and his wife. There's some indication that this defendant was engaging investors in Massachusetts and Maine, and we are concerned he would find ways to continue to entice investors if he was out and free. His wife has filed for bankruptcy. His liabilities far exceed his assets as far as we know, although there is a real question about where his assets are and what happened to all the money that he took from these investors. There is a substantial judgment against him by this company called Premier Capital, and that's a judgment of approximately $800,000 that he has looming over his head. The amount of the alleged theft in this case, as I told you, is approximately $300,000. We know that he had approximately 20 active credit cards, some of them with significant balances, at least one with a balance over $18,000. We also have concerns about certain property interests that the defendant may have and how that reconciles with the financial affidavits that he submitted in this case. His financial affidavit that he submitted when he applied for court-appointed counsel shows only his primary residence, which is in foreclosure. But it does appear from other documents, and I've included those in the packet that I gave to the court and to the defendant, that he did own, or he does own still, rights to construct 2 condo units on Silver Street in Dover, and that he took a mortgage of $40,000 against that interest. So, this defendant should clarify if that is in fact a property interest, because it appears that it is. And if so, he needs to explain to the court why he has not disclosed that on his financial affidavits. We also need to know if there are any other undisclosed property interests that he has not come forward with. That's one of the big concerns here, where does the money go? In terms of his risk of flight, the defendant, even though he was at one point prominent in the Dover area, he has successfully severed most of those ties with his friends and acquaintances by making them his investor victims. In that respect, it's really difficult, I think, to say that this defendant has any ties to this community. Many of the victims who are here today have been openly hostile to this defendant. At least one camped outside of the defendant's home before he was hospitalized, holding signs demanding repayment of his investment. It does appear that this defendant has a very small support system outside of the immediate family, and that he doesn't have what a reasonable person would consider ties to Dover. He effectively severed those ties. If anything, his presence in Dover could provoke outbursts and disruptions from the people that were victimized by this scheme. In terms of the danger to himself or to others, there is evidence that this defendant had a premeditated suicide attempt that he attempted to carry out last fall to avoid his financial and his legal problems. He attempted suicide by attempting carbon monoxide poisoning on the Maine coast. copies to the defendant, that make reference to this plan for suicide, this plan to basically escape responsibility for these charges. One note says that it's in reference to insurance, his own personal insurance. The note read, quote, "After 3 years, suicide covered." The other note said, "No defendant, no trial." And that's pretty clear evidence of an intent to avoid responsibility, and it goes directly to the issue of risk of life. Last September, both he and his wife changed the beneficiary of their life insurance policy and named a family friend as the beneficiary. That was just weeks before this attempted suicide attempt. And I can say that the state has received only very limited information about this condition of discharge from the state hospital, and no information about why this defendant is no longer a danger to himself after those 6 months of being hospitalized. The discharge notes, though, do say that the reason for admission was assaulting/threatening behavior. So that's why he was admitted. That obviously raises concerns about him being a danger to others. And frankly, I can tell you that some of these victims in this case are concerned about having contact with him and concerned about retribution from him. So there is that concern that he might pose a danger to others. There was also a concern that he might harm himself. And in so doing, depending on exactly what his plan was, he could pose a potential harm to others within the close proximity to him. We do know that he's taking medication upon his discharge for depression. So this defendant has every reason in the world to want to avoid a trial. He has shown that he will go to extreme lengths, including a premeditated suicide attempt to do that. We don't think that he's a risk. We think he's a substantial risk of flight. He thinks he's a substantial danger to himself and to others. And for that reason, Judge, we submitted the state's proposed bail conditions, which ask that bail be set at $150,000 cash only, and that in addition to the regular terms and conditions of bail involving no contact with victims and weapons and other kinds of things that go into every bail order, that there be specific conditions which are outlined, including that he must be regularly supervised, that he be prohibited from leaving Jogo without permission, that he must immediately report to court any change in his living arrangement, including not only where he was living, but with whom, that he must surrender his passport to this court, that he be ordered to comply with the permanent injunction now in effect against him, that enjoins him against engaging in securities fraud, unlicensed activity, and unregistered securities, that he's prohibited from engaging in real estate or other business transactions aside from necessary household management, and that he's prohibited from soliciting investments in any form and in any state. And of course, that's in addition to the other conditions, which most importantly would be absolutely no contact in any way, manner, shape, form with any of the investor victims. Thank you.
Thank you, Your Honor. Just scanning over the proposed amendments here, the state has put forth, we certainly don't have any disagreements with any of those other factors. I guess the only issue here is the state would like to see $150,000 cash only. We're asking for a $5,000 cash for surety guardian, following was involuntarily committed, has signed the leases, and those have been turned over to the local jail. We're talking to wire who assesses people to jail, and read over those reports. I know with the mental health director, their Rowlett has read through more detailed health reports. So they have been assured, as obviously the New Hampshire State Hospital has been assured, that Nick, Mr. Skaltsis, is very stable right now. And obviously he's been released to his home with the provisions as the discharge plan shows. As for details about where he would stay and who he would be staying with, these are details that I have discussed clearly with the state as well as Strafford County Corrections and the jail. They're no secret, but this is a home that Mr. Skaltsis has lived in for quite a bit of his life. And he really lived with his wife. It is certainly very rural. And that address is very good by the corrections. They can supervise that. The address is 6 Eric Drive. Almost within view of the courthouse. I do want to bring up and address some of the concerns that the state has brought up here. They're referring to former friends of Mr. Skaltsis, investors. I would say they would be lenders at this point, at least from the discovery that I've been reviewed so far. These are unsecured promissory notes to pay back. These are not unsophisticated lenders. These are people who are familiar with Mr. Skaltsis, familiar with his work in the community, familiar with his business plan. And he, as obviously they've had plenty of time to establish their civil claims. I know you are familiar with some of those because they've been working their way through the courts. So they have certainly had time to secure their civil claims. These assets that the state continues to search for and holds on have been thoroughly researched. I know the home has been searched thoroughly. The bank accounts have been frozen overseas. All the assets have been frozen overseas. And all the parties have been represented by counsel. Right now, the amount of cash or assets that Mr. Skaltsis has access to is very small. I can address the court from the state's concerns. His mother, who is 89 years old, and does allow the state, as well as with a great honor, and other extended families have agreed to help cover necessary costs. They have, for instance, been making sure that the gas is not turned off, the electricity is not turned off on the home. And in fact, he's compelled to maintain that home because it is a totally foreclosure action at this point. So there is no concerns that that house will be maintained for him and livable and necessary would be covered. I believe Mr. Skaltsis is now able to draw a small sum into Social Security. They also would help with at least surety because they're comfortably enough. He has no problem with making sure that he continues to have contact with his family practitioner or with the psychiatrist, and well has been recommended. No problem having medical checkups. Corrections can come over at any time. He can report community corrections at any time. He has no objection to having the test bracelet to ensure that he is where he says he is, and to not venture further out. I would just ask the state if they have specific concerns as to these lenders or friends being threatened, and certainly that information could be used for them to law enforcement or if there's a specific complaint, and to get that in front of us. So right now, I'm not aware of any threat that Mr. Skaltsis presents to anybody else. He's certainly in no position to go out and solicit loans from his friends. There's been no shortage of being records on this case, and they're all familiar with it. So I think the fact that community corrections in the New Hampshire Hospital has assessed and addresses the danger to himself, the danger to the community, I don't see any basis for that. And in terms of a flight risk, I can assure this court that if anything is motivating Mr. Skaltsis to stay in the community, it's to address these criminal charges. It was devastating and embarrassing for him not to be able to pay back those loans to his friends, to those lenders. And obviously that was overwhelming. 8 months ago, that was almost too much for him. Since that time, he has stabilized and in fact been somewhat energized and motivated by the fact that he's now able to that seem that the hospital is a little bit concerned about that. Those concerns are unfounded. He's certainly shown that he is adapted and done fine there. He looks forward to being out in his home, but he certainly has not been, for many times, since the depression, since the release from the hospital. For those reasons, I think $5,000 cash for surety with community correction is more than enough to assure, along with all the conditions that the state is asking, to assure that Mr. Skaltsis will reasonably appear during the all hearings and will not go to the effect of himself or the community.
The only thing I would say is that this assessment that we received 2 minutes ago, the underlying assumption is that the defendant reports a stable residence with his wife and ties to the community. And I think that's really one of the issues with that dispute. He's going to be in a home that's facing foreclosure. We don't know how soon we thought that sale was coming imminently. And I don't think that we've told us yet how long they expect that he'll be in that house before it's foreclosed on, and waiting close after that. And ties to the community. The assumption here is that those things are in place, when in fact we do not. And with those not in place, I wonder, because I can tell you that this assessment, they didn't simply call the state and to try and get our assessment of where we thought he was in terms of the stable residence and ties to the community. And I think if we asked if they inquired in the community to find out if it's broken on both sides.
I can address those concerns. His wife is living here in the community, we'll be living in the home. His daughter also lives in the community. And we certainly notify the court of community corrections more than 24 hours in advance. If that foreclosure becomes imminent, we need to go back to the jail or secure another approved residence within the community nearby.
Is there a date set for foreclosure auction?
There is not, Your Honor. My understanding is that Citibank has made an appearance, but foreclosure has not begun on that home.
You have any of the complaint that has names of the...
Actually, this is from the Superior Court, that's why I thought you had it. This is from the clerk's office, and it has all of the complaints attached. Right, this is what we received from the right, you can say, copy of all of them. Yes.
Well, if we're comfortable with all pictures.
All right. What is the recess?
The following bail is set at $150,000 cash or corporate surety. Conditions of your release are as follows. You shall not commit a federal, state, or local crime while on release. You shall appear in this court at all times scheduled. You shall keep on file with this court a current mailing address and check daily at that address for receipt of notices in this case. You shall execute a waiver of extradition. You shall be supervised by Strafford County Community Corrections. The supervision shall be by GPS or by whatever other conditions community corrections deem necessary for supervision. You shall not use illicit drugs or alcohol. You shall submit to random drug and alcohol tests as directed by community corrections. You shall live at 6 Eric Drive in Dover. You shall not use or possess a firearm or other deadly weapon, including ammunition. You shall surrender your passport to the clerk of court. You shall avoid all contact, direct or indirect, with persons who may be a victim or potential witness in the subject investigation or prosecution, including but not limited to Gary Green, Eric Wasson, William Petropio, Janice Woods, Fergus Cullen, Michael Zelensky, Judith Zelensky, Donald Andolina, James Gershurin, Carlo Natoli, Phyllis Woods, Estelle Condero, John O'Connor, James Amara, and Douglas Deedy. I'm pronouncing that correctly. You are restricted to your residence at all times except for medical needs or treatment, religious services, and court appearances, all of which must be pre-approved by community correction. If you violate any of these conditions, you're subjecting yourself to immediate arrest and order of detention until trial and possible prosecution before contempt of court. Do you understand?
Yes.
Any questions? No. In the name of custody of the sheriff, please.
And the next matter will be Nickolas Skaltsis, arrest as